The topic of this discussion is the following. A U.S. court will not recognize a foreign custody order if the order fails to make any determination as to the best interest of the children. Hi, my name is Gabriel Sauma, professor of Middle East Constitutional Law and Middle East Studies, expert consultant on Islamic divorce in U.S. courts, expert consultant on Middle East laws. Today, I'll be talking about a case in Florida in which the court sided with our opinion and refused to recognize a court order of custody from the United Arab Emirates. I was called on to testify in this case as to whether a custody order obtained from the Court of First Instance in Abu Dhabi can be recognized in a U.S. court if the order does not take into account the best interest of the child. The wife is a U.S. citizen. She traveled with her husband to the United Arab Emirates for work. While in the UAE, she had a conflict with her husband. She decided to divorce him in Abu Dhabi. The husband returned to the US with his two children. The wife decided to stay in Abu Dhabi, and later she got married over there. So she went to an Islamic religious authority along with two male witnesses and converted to Islam by stating the Islamic Shahada. Shahada means that a person who wants to convert to Islam has to state the following. He has to say, I confess that there is no God but Allah and that Muhammad is his messenger. Once he or she states the Shahada, she become she became a Muslim. She was given a certificate of conversion. So, what are the implications of that, of converting to Islam? Once a person converts to Islam, his or her marriage ends, and her minor children become Muslims too, unless the husband also converts to Islam. In this case, the marriage stays the same. In this case, the husband was residing in the United States along with the children and has not converted. The wife went to the court in Abu Dhabi to have her conversion and dissolution of marriage registered at the court of the first instance. The divorce was granted solely on her conversion. A few weeks later, she sought a court order in Abu Dhabi granting her custody of the children. The court of first instance in Abu Dhabi granted her custody of the children based on her conversion to Islam. The court did not take into consideration the best interest of the children. When she came back to the US, she filed a lawsuit against her husband seeking recognition of the Abu Dhabi divorce and custody orders. We objected to the registration and enforcement of the United Arab Emirates order of divorce and order of custody of the children. The court agreed with our position and denied the wife's request for registration and enforcement of the United Arab Emirates divorce and custody orders. The Florida court determined that the United Arab Emirates process failed to make any determination as to the best interest of the children. Petitioner, i.e., the wife, was not required to produce any evidence of the best interest of the children. Rather, she merely needed to have claimed to have converted to Islam, at which point custody standards were applied. The United Arab Emirates process applied a maternal presumption which no longer exists under Florida law. The UAE custody order provides for an automatic change in custody from the mother to the father when the son reaches the age of 11 and the daughter reaches the age of 13. Such automatic and prospective custody changes without a present determination of the best interest of the child at that time is contrary to the public policy of the state of Florida. Thank you.